April Ford, who's in the courtroom today. She is the mother of 8 lovely children, and this is an appeal from the judgment of the General Sessions Court in Jackson County, Tennessee. The primary issue for this appeal today is the trial court separation of the siblings. There were 8 of them, and the reason for the separation of the siblings. By the time this case got to trial, there were actually 5 minor children. This was a very traditional 24-year marriage where the parties, as I said, had 8 children, 4 boys and 4 girls. 4 were minor at the time of the final decree, of the entry of the final decree, but 5 were minor at the time of the trial, which was in August of 2023. These children had a great relationship with their dad until he left the family, moved in with his girlfriend, and filed this divorce. He also continued to reside with his girlfriend and her 2 children throughout the pendency of this divorce, which pended for 3 years. As I was stating, this was a very traditional marriage, and these parties were very practicing of the Christian faith, and I had instilled in their children what was right, what was wrong, what was moral, what was immoral, and the mom stayed at home with the children primarily, disciplining them, homeschooling them, and being their primary caregiver. That was not disputed at trial. The parties had 1 car, which also might illustrate to us why these children were all so close by the time this case got to trial and by the time this divorce was filed, because they were used to being at home. Their mom didn't have a car because their dad used it to work and to provide for the family. The mom testified at trial that dad was a great dad. There was no dispute that dad was a great dad, and that these children loved their dad. There was no dispute about that. I'm pretty sure there's probably no dispute that these children, the older children particularly, were extremely devastated and upset when their father did what he did. Sometimes it's easy for us divorce lawyers, because we see a lot of that. It's easy for us just kind of say, look, it is what it is. Kids are resilient. They'll get over it. This was a different kind of case. This was such a close-knit family, including dad. And for what happened with dad, to have him leave the family, move in with the girlfriend and her 2 children, such that he didn't have room for his own children.
Well, and understanding all of that, and
Yes.
I've read what you've written. Just to break this down to where we are, you're alleging that the trial court abused its discretion.
Yes, thank you.
In
Yes, Your
making
Honor.
this decision. I've read the trial court's order, and the part, and I'm paraphrasing, stuck out to me is this was the worst case of parental alienation that the court had seen.
Right.
So where in the record am I going to find that she abused her discretion with what I read are pretty detailed findings
Right.
in her order?
Well, the detailed findings in the order tend to gloss over this 24-year marriage where my client was the primary caregiver, did all of these things. If the court, what the court primarily rested the decision on was the factor regarding facilitating and encouraging a relationship between the parent and the children. But the proof at trial, which was really uncontroverted, was that the mother was doing just that. She testified about all of her efforts, and the mother, the court said at the outset of this case that it was the worst case of parental alienation. There were things that happened like a year before the divorce trial. By that time, this mother, who was very devastated as a wife for what all had happened as well, had, for lack of a better word, cleaned up her act. She realized she'd had to move on as far as her angst, and she had to help these children move on as far as their angst about this. She encouraged a close and continuing relationship with the dad, and the court found both parties to be credible witnesses. So that finding was more of a retrospective. The court was saying that, this.
Isn't history, though, a fair consideration there? Isn't history a fair consideration for the trial court in making that determination, and as part of how it's looking at facilitation of relationships? And here there's a rough history for mom in terms of what the trial court found in this case.
There's a rough history of about a year. And this was a 24-year marriage. these kids, there were kids who were in college or graduated from high school by this time. Mom did a great job with these kids. I mean, they were, most of them were homeschooled, came out with honors. To extract just the facts that are unfavorable to the mother in the historical setting is what I refer to in my brief as throwing the baby out with the bathwater.
You mentioned that this was a close-knit family,
Yes.
and conventionally you'd keep the kids together. I wonder if this is a case in which the very close-knit nature of this family actually cuts against that in terms of the trial court's findings, because the trial court has this concern about the influence of the older children over the younger children with regard to the relationship with dad. And the trial court seemed pretty concerned that if the older children are continuing to influence the younger children, that's going to dramatically undermine the relationship with dad. So is the trial judge wrong in that analysis? Am I misreading that analysis? What do you, I read that in as understood that to be part of the trial court's concern, that close-knit here was actually in some respects working the other way. Although conventionally, I think it would work for keeping the kids together. Here, close-knit may point to why you're separating these kids
Right.
apart.
Well, the real reason, your analysis is not wrong. That's what the court found. But the end result in separating these children was basically that the older children were vilified, and their father, who arguably caused all of this strife, was glorified. And so that is why I'm saying the baby was thrown out with the bathwater. Because yes, these were important considerations, no doubt, the history. But how can we just look in a bubble of 1 year, 2 years, 3? By the way, this divorce was pending through COVID. None of us was at our best. You're truly included. And this divorce was filed in November of 2020. So, not only was everybody a close-knit family, everything changed for a couple of years. And the separating siblings is a drastic remedy. And I cited the Schaffner case, which such extreme things were happening in the Schaffner case, where one of the children was pushing a child down the stairs, broke her arm, multiple hitting, pushing, that kind of thing. In this case, these older children who were devastated because in their eyes, the guardian ad litem even noted this, in their eyes, their father had committed the ultimate sin that he had taught them was the ultimate sin, and not to do, or at least one of the 10, okay, and that this was not something to do. And he was very unapologetic about it. He was upset when they were disrespectful to his girlfriend, and he was upset that they just didn't come around and want to just be, okay, Dad, we're okay with this. He lived with her the entire course of this divorce, and that didn't help. And I just am submitting that the court's analysis doesn't really take that into account. It's easy to pick out a couple of big deals to talk about and then bury the lead. And the lead is that this mother had been a fantastic mother throughout, and she still is. She went through a rough patch. The family went through a rough patch. But again, what we've done is we've vilified the children and really their mother, and we've glorified the dad, who arguably caused every bit of this. There were no complaints from either party about how they parented these children up until November of 2020 when this divorce was filed. So separating the children is a really drastic remedy, particularly in a case like this where they are close-knit. And even if they hadn't been close-knit, Your Honor, to your earlier point, they were in 2020. Circumstances required it. So we submit to Your Honor's point earlier that the trial court abused. Let me back up a bit. The trial court was really trying to do the best she could. I could see that. She put a lot of thought into the ruling, but I'm just submitting that really this was an erroneous assessment of the evidence when you have the two parties who have been found to be credible witnesses. And they were both really, you could tell they were being honest in their testimony. And so I would just submit that when you review all of the information and you look at the factors vis-a-vis both parties, that the vast majority of them are going to swing in the mom's favor. And I understand it's not a mathematical 3, in favor of the mom, 4 in favor. I understand that. But again, in 24 years with 8 kids, that should count for something. And that the mother was primarily responsible for that. and responsible for. I believe one of the children got a 32 on his ACT. So she clearly was doing a lot right.
What about
And,
the therapy support aspect in this case? The therapy support
Yes.
aspect, and the trial court seemed to have some concerns about mom's approach with regard to supporting therapy for the kids, and that dad was more supportive. And is there any error there with regard to the trial court's determination, and that seemed to also play in terms of the consideration here?
Yes, Your Honor, I agree. And that did play in, but it was resolved by the time of trial because the kids were in therapy and had been for several months. Mom testified that the children had started opening up. And that was a good thing. And,
Was that after a temporary order where?
Yes, Your Honor.
So that was after the younger children were
Yes.
spending time with the dad?
Yes, Your Honor. The younger children, and let me also remind the court that the court didn't separate the older children from the younger children, really, because the dad still sees those kids. I mean, the parenting plan says he gets all of the children, which are 4 minors now, every other weekend. Now, if there was a huge concern about the older children, it seems to me that something different would have been done. What the real thing in the backdrop, and I think the court probably struggled with this a little bit, was that the dad, he couldn't have had all these kids at the same time. I don't know where they're sleeping. Okay, they didn't have room. They didn't have room at the time. He testified, I don't have room, but I want to get room for these kids. And when I do, I want to work toward 50-50. Even the dad felt like 50-50 was in the best interest of these children, but he couldn't do it because he didn't have room. So to your point, the father was, providing, for therapy. He wanted therapy. The mother may have been a little resistant, but it was in place at the time of the final hearing. And the one thing that the father really could have done to put a lot of this to bed as far as, the kids' feelings was, he could have put a roof over their head that his girlfriend and her 2 kids didn't live in. Thank you.
Good morning. I am Kelsey Miller of the Putnam County Bar, no relation to opposing counsel. I have been in this case from the beginning, and there are several issues with respect to my colleague that I fundamentally disagree with. I noticed in the brief, it was mentioned several times that Judge Gibson glossed over a lot of things. Judge Gibson does not gloss over anything. As the record will reflect, she took about an hour-and-a-half break to go over her notes. This was a lengthy hearing. And by the time we got to the final hearing, the parties had been in front of Judge Gibson several times. And I think that's significant in this case because when we're looking at whether a trial court abused its discretion in making these decisions, I think it's important to note that when the case first began, the father was not unapologetic about what he's done. I'm not here to make father a hero as a husband in a marriage. We tried to concede the fact that there were mistakes made in the marriage when father filed for divorce and our proposal stated that mother should be the primary parent as she had been. That is a concession on the father's part that he's made the mistake. He understands that the kids were upset. He understood that. He acknowledged that. That's why he submitted the proposal, stay with your mother, that's where the stability is. But as the case progressed, it became readily apparent that the older children who were old enough to understand what was going on were understandably upset. So we can't stop at just identifying what the problem is. And that's what I would submit to the court happened with the mother throughout this case. Throughout this case, the theme was, well, the kids are upset. Well, they're upset. They're very upset with you. We can't stop there. We understood that the children were upset. That's why there was an agreed order in 2021 from the counselor's recommendations that the older children would not attend visitation with the dad. They would allow the younger children to go. And that order from 2021 from the counselor's recommendations stated the older children will not escort the children out. They won't be present for that visitation, with the idea being that the younger children who were not so upset with father because they were too young to understand what had gone on, that they would have a great time with dad, they would come back, and they would influence the older children, rather than the older children stopping the younger children from bonding with dad in retribution. However, even though we entered that agreed order, Mother's first counsel withdrew. What happened with that, I'm not sure, but it was shortly after the entry of that agreed order that counsel withdrew. Mother got a second attorney. We continued to try to work to get the kids into counseling because, again, we've identified the problem. We acknowledge the problem. We tried to fix it. We tried to find solutions. For the years that followed, we still had issues with, and this is what Judge Gibson alluded to in her order, when it comes to factor number 2, facilitating and encouraging a close and continuing relationship with the other parent. Some of the factors, Justice Usman, you stated it, the past and future for potential performance. So Judge Gibson looked at her past as far as it went to complying with the court orders.
Counsel, is the judge here, though, punishing Mother for her failure to appropriately handle this relationship when it fell apart in terms of the kids with their anger? And isn't the trial judge also saying, hey, Mom's really made a lot of progress here, and Mom has improved in terms of how she handles those issues? She's doing much better. Is the trial judge here in the end punishing her for what she did in the past rather than thinking about the best interest of the child going forward with where Mom's at today rather than where she was a year earlier?
I would submit that the trial court was very cognizant of the fact, and where she found her credible during the final hearing. She heard things from Mother that she had been wanting to hear for years. And it took the removal in March of 23. Now, this was after a warning shot was fired by Judge Gibson, I think in 2022. She said, if this does not improve, if these children keep influencing, and if you keep failing to remedy that, I will have to think about something more drastic, such as removal. It did not improve. So much so that there was an order of protection that was drafted by one of the older children that was still in the home with Mother, where he gathered up all of the children, had the children say things about Father. And so when Judge saw that, she said, you're not getting it. So when the children were removed, that is what woke Mother up. So then 5 months later at the final hearing, she was not punishing Mother. What she found after she talked to the children is, I acknowledge, Mother, that you have now seen the damage and the severity, and you're acknowledging that.
So is your reading of the order then that it's not just retrospective in terms of, Mother was doing these things that were bad in terms of alienating, but it's also, there's a prospective concern?
There was a prospective concern, and what we had noticed by the time we got to the final hearing 5 months after the removal of the younger 2 children is that things were improving. Things were finally improving. Instead of things getting worse, and you can see from the record, the first order where we tried to address the problem by asking that the children attend counseling and that the children visit separately so that that influence doesn't permeate the younger children, there were 3 of the young minors that were supposed to go to that visitation. By the time we got to trial, the 3rd one had already become alienated from the father due to the influence of the older children, so that's why only the younger 2 were removed. And so as far as retrospective versus prospective, we were finally seeing some progress. Mother was finally acknowledging with her 4th counsel, and after removal of the children, she was finally acknowledging, I understand how this is affecting and how big of a deal this is. So again, we're not, my co-counsel or my opposing counsel said that Dad was glorified. He was not.
Why isn't the trial judge off base here in terms of placing blame upon Mother with regard to the challenging relationship that exists between Father and some of the children, rather than Father's own behavior here? And opposing counsel essentially looks out and says, Father's the one that taught kids certain values and then lived in a manner inconsistent with that, and then continued to live in a manner inconsistent with that. Why is the trial judge not off basis in putting the blame on Mother as opposed to Father in terms of the undermining of relationship that occurred here?
I would submit that she did. She did have criticism or critique for both parents. She did. She did speak to the father, and she said, these children, whether justified or not, they are expressing fear of you. They are expressing that you're violating personal boundaries, and you need to work on that. The fact that Father... Again, the fact that we had proposed a solution about counseling, there's only so many times that father can take accountability for what he did. There's only so many times he can do that before we have to move forward with that. I don't think that Judge Gibson, again, she's not punishing and putting all the blame on mother. However, through the course of the case, where we were acknowledging what the problem was and finding solutions, mother had an attitude of not only harnessing the feelings of the children, but wielding that, weaponizing that against the father. And I would submit this, where it was a 24-year marriage with 8 children, 1 car, mother was homeschooling. These kids were her buddies. These kids were very secluded, very isolated, as was mother. So when mother was hurt, understandably so, the older children picked up on that. They were team mom, and what was happening is they wanted to make sure that dad was punished. Mother, and again, we gave this some room to breathe a little bit, waiting for mother to kind of compartmentalize that and say, this is an issue between me and your dad. This is about our relationship, not your relationship as father and children. And we did keep hearing about the biblical aspects of this was the ultimate sin. I always had a question about honor thy mother and father. That's one of the commandments as well, but that was never brought up. The attitude always seemed to be, well, they're upset. They don't want to visit you. They don't want to see you. They're upset. So what Judge Gibson saw over the course of this case was mother's lackadaisical attitude about that. I'm not saying that a person in her situation should be father's champion, but when we consistently, and the court consistently admonished her and told her this is alienating behavior and is getting to the point of psychological abuse, because the younger children, they did not have this anger toward their father, but the older children were making sure that it continued, that it happened. And you'll also see in the record where mother had said things like, don't bring them toys, I'll just put them out in the street. It's not that father was unapologetic. He was very apologetic. He understood what was going on. There's also been a big deal made about the fact that he was living with his girlfriend. Well, the record reflects that his gross income was $2,908 a month. He had several minor children with a mother who was homeschooling the children, so she was working part-time with DoorDash. Child support had to be paid, support had to be paid. On that income, father didn't exactly have a lot of means to go anywhere else. It's not that he was living with his girlfriend and trying to rub it in everyone's face. The financial realities is he didn't have anywhere else to go. So while he was trying to get some traction there, trying to get traction with his kids, it just continued to get worse. So Judge Gibson, looking at the abuse of discretion, I can't see how anyone could argue that she applied the incorrect legal standard. I think she applied the correct legal standard. Reached an illogical result. I don't think an uncommon or a rare result equates with illogical. I understand that separating siblings is a drastic remedy. Judge Gibson tried to avoid doing that, but it got to a point where she saw no other way. She was not punishing mother at that point. The record reflects that she talked to the older children, and she could see, to your point about prospective application, that if these children were to do 50-50 time but continue to be exposed to these kids where it had just not sank in with them, that their influence to these younger children could be harmful. Because of that, she couldn't say that these kids should stay together. We were seeing progress based on the separation. And to my opposing counsel's arguments that the children were starting to open up by the time of trial. There was an agreed order in 2021. We didn't go to trial until 2023. I don't understand how we could argue, well, this is great news. Mother is so compliant. If these kids had been in counseling consistently in 2021, they would have opened up sooner. We could have worked through this, and most likely, the children would have had a completely different living arrangement with the parents. As far as there being a clearly erroneous assessment of the evidence, I don't know where the argument is about an erroneous assessment of the evidence. She listened to both parties. She had a history with this case, talked to the children, and then the other element is that the reasoning caused an injustice. Now, the brief from the mother stated that this was a great injustice to these children. And as I've said in my brief, it's not an injustice to the children because they don't like it. The injustice, and it's not just about the older children, it's about the younger children too. The pattern that this was causing in this case was that the children, and it was trickling down to the younger ones. Again, as evidenced by the fact that we started with 3 younger children visiting with dad separate and apart, but then it got to the point where it was only 2. The injustice would be if these children were continued and the mother were continued to, if they were allowed to alienate father to the extent that they were, all of these children would have been without a father. And they're too young to understand what they were doing. Counseling would have helped that. Do you all have any other questions? Okay.
No.
Well, I would submit that the court did not abuse its discretion, and we would ask that you uphold it. Thank you.
Thank you.
Ms. Miller? We're both Millers with K first names.
Well, when I saw you were both, it was coming from Jackson County, I wasn't surprised.
And, Your Honor, the father did have a place to go. He never had to leave. He voluntarily left the family and didn't get a place to live other than his girlfriend's home. He probably didn't have the money to pay for a separate place. But there was absolutely no real reason he had to leave except he wanted to be with another woman. So that's what I guess you would say bothers me about the whole thing. The dad told these kids not once, but twice, I'm coming home. In the first several months, and still we're still in COVID. Where's Dad? Dad, please come home, we love you. The kids were still saying, we love you. Even the older ones, they wanted him to come home. But he left them in their minds, not once, not twice, but 3 times. When he left and filed for divorce, when he told them he was coming back and he didn't, and when he did that again. So, again, these kids were vilified and the dad was glorified. And he didn't even have room for all these kids anyway. So it's really almost just worked out conveniently for him because he really wanted equal time with all the kids, but he couldn't sit in court and say, I've got room for them. So what he did was create a narrative that would have him the ability to have the 2 children that he could actually maybe have room for, and then just let these other kids just stay with their mom. Things did improve. The court noted that. Opposing counsel did note that as well. By the time the case got to trial, the court was very satisfied that the mother had made big strides. So I feel like that she did not prospectively find that there was going to be further facilitation or further lack of facilitation or an encouragement of a relationship. What she did was heavily rely on history. And again, it's relevant, but that was really mostly what she relied on, because by the time the parties got to trial, they had agreed on joint decision-making in all major decision-making areas, which is a big deal for this mom who basically had made the decisions throughout by default because that was her role. But in the divorce setting, she had come that far where she's like, yes, let's do equal time, and let's have joint decision-making on these major decision-making areas. And I think that should be a big indicator to the court that her whole mindset had changed, as well as the fact that she was actually asking for equal time. Because in her initial parenting plan, mom asked for dad to have 55 days a year. Dad even basically asked for 80 days a year. But by the time of trial, mom said equal is what's best for our kids. And joint decision-making is what's best for our kids. And those are the indicia of someone who's going to facilitate and encourage a relationship. Thank you.
Thank you both. Would you call the next case, please?
Ching Han Belfio